All right. So the topic of the seminar is due diligence in corporate law. We are going to be discussing about what is due diligence, what is the scope of diligence when corporate lawyers do conduct diligence, why is a due diligence done in the corporate law industry, and we're going to be talking about the sections of due diligence when corporate lawyers look into what due diligence we need to do on a company. Other than that, we're also going to be touching on the career opportunities in corporate law. And then we can do a Q&A session. But please feel free to stop me if there's any doubt or any clarification that you would like to seek. We can take it up accordingly. Now, coming on the meaning of due diligence, what do we understand from the term due diligence? Now, diligence is basically a detailed and independent examination of the affairs of a company. So basically, corporate lawyers need to do an investigation or examination of the affairs of the company so that, we understand that what is the company doing, what is the level of compliance of the company, how is the company doing financially and in terms of compliance with law, how compliant is it? So we do a due diligence on the company basis that. Now, why do we need to do a diligence? Basically, before you must have heard of this concept called buyers beware, right? Now, whenever a buyer wants to buy a product, they will always look at the defects or deficiencies in a product to understand if the product is purchasable or not. So similarly, when an acquirer wants to acquire a company, the detailed examination or detailed investigation is required to do on the target company so that the acquirer can easily acquire the company and it protects the acquirer from the past liabilities and past red flags of the target company. We do a due diligence because we want to know that there are no red flags or there are no surprises in the target company that an acquirer may not be aware of. So this is why a due diligence is very important in the corporate law industry, and that's why in mergers, acquisitions, amalgamations, all the corporate restructuring transactions, we need to do a due diligence. So before we basically dive into the sections or the chapters of a due diligence, we need to understand where all we need to do a due diligence. As I said, this diligence is basically done in case of corporate restructuring transactions, and there are different types of corporate restructuring transactions. Like in this case, what you're looking at is an example of a merger. So if a company A is merging into company B, then we will need to due diligence. We will need to do a due diligence on company A as well as company B, because company B is the resultant entity and company B will want to know the financial health or the compliance level of company A, and company A would want to know the compliance levels of company B. Similarly, this is a separate type of corporate restructuring, which is amalgamation. When company A and B is merging into to form a third company or a new company, company C. This is also where we, do a due diligence on company A and B to understand that, what is the level of compliance in both the companies. And if they want to, proceed with the amalgamation. There may also be red flags highlighted in case of company A or company B, which the other side may want to stop at the diligence level only and not proceed with the corporate restructuring. Again, the third example is that of a demerger. In this case, what happens is there is a company, a division of the company is hived off or demerged into a separate company. So that's an example of demerger. And primarily and majorly, what is prevalent in the industry is that of a share acquisition. In this case, a company A is acquiring the shares of a company B. So that is indirect ownership. When you acquire shares of a company, let's say company A in this case is acquiring 100% shares of company B. So basically it is owning company B. They 100% shares are owned by company A in this case. So that's why the diligence will need to be done on company B to understand that, if it is worth purchasable and if company A would want to proceed with the acquisition. Now we need to understand the scope of diligence. Where corporate lawyers come into picture is when we are asked to conduct diligence on a company. We look into different types of aspects of a company in order to understand the compliance level, how the compliance of the company is in different aspects. So firstly, there is litigation. We look at the litigations or filed by or against the company. Then we look at real estate. There is corporate or compliance section, which we look at, which all of these chapters and sections we'll deal into the next slides a little deeper. But I'm just giving you an overview of the scope of diligence, what we need to look at and what corporate lawyers look at while doing a diligence on a company. So we have material contracts, we have IPR, we look at the licenses and permits obtained by the company. We look at loans and liabilities obtained or granted by the company. There is HR chapter also where we look at the compliance level of employees related labor laws and employees related laws. Then we look at the real estate section where there is properties owned or licensed by the company. Now coming into details of each and every section of diligence. Firstly, we cover the corporate chapter. Now, corporate chapter of the diligence basically focuses on the compliance level under the Companies Act 2013. So how a company is maintaining board meetings, shareholders meetings in accordance with Companies Act, whether the quorum is correct, whether the minutes are maintained as per Companies Act 2013 and the secretarial standards. Then we look at the memorandum of association and articles of association to understand what is the level of business, of nature of business of the company. Then articles, may we see the share transfer restrictions to understand that, if there are any restrictions amongst the shareholders of the company, how will we come into the picture? These are the kind of things that we review and we kind of flag to our client, which is the acquirer, in order to for them to make a decision that whether a target company is worth purchasable or not. That's how diligence come into picture, and that's how diligence helps acquirers to decide that whether a target company is worth purchasable or not. Other than that, we also look at the ROC form. So you must have seen under the Companies Act, there are a lot of forms which are required to be filed with the ROC. ROC is Registrar of Companies. This is where, we need to see that whether the company has been compliant in filing forms throughout the years. So we review the forms, we review the periodic forms as well as the statutory forms which are required. Then we look at the shareholders agreements, if there are any. So shareholders agreement is nothing but an agreement inter se amongst the shareholders of the company to understand that if we are acquiring the shares of a company, how will we have those rights? So that basically depends on the number of shares or the percentage of shares that we intend to acquire. Now, if we intend to acquire, let's say 75% of shares of a company, we will want a lot of rights because we are the 75% owner of the company. If we are 100% owner of the company, then we don't need to have any shareholders agreement because there will be no other shareholder. We will be only the only shareholder in the company. So this is how in different corporate restructuring, we need to look at documents from that perspective. Then you must have seen under the Companies Act, we also look at statutory registers. There are requirements of maintaining register of directors, register of members, register of charges. There are a lot of statutory registers which are required to be maintained. So we look at, in case of a target company, what is the level of compliance there? And then we review these statutory registers to understand whether they're in compliance with the Companies Act. The second section is indebtedness and financial assistance. Now, in case of loans, uh, loans granted or basically availed by the company, we need to understand that, what are the loan agreements which have been entered into by the company. Let's say if a company has availed a loan from Axis Bank, and we need to go through the terms of the sanction letter, we need to go through the terms of the facility agreement to understand if at all they've, been in default of the repayment of loans. These are the kind of things that we look at while doing a diligence, so that our acquirer is comfortable with the financial position and is comfortable with the well-being of the company. Now, in case of employees, we look at the compliance in relation to labor laws. We look at whether the company has obtained registration under the ESI Act or EPF Act. These acts basically require a registration to be obtained by the company. So we review those registrations. We look at the expiry date. If the licenses or registrations have been expired, we look at the renewed copy. We basically see if they are in compliance with all these labor acts, including Gratuity Act, if they've been, making payment of gratuity to the employees. And all of these are all real examples. So as law students, we only review or we read these labor laws, but in practice, when you want to, do diligence, we will need to do the practical aspect and see the practical, approach for seeing the compliance of these acts. That's when we get to see the practical analysis of these and applicability of these acts. So as I was saying, that we basically look at the compliances under the Gratuity Act, the EPF Act, Building and Construction Workers Act. Now, all of these acts we basically get to discover basis the business of the company. So like in case of Building and Construction Workers Act, that is not applicable to all the companies. That is only applicable to a certain set of companies. Then there is Maternity Benefit Act, which basically requires you to maintain a policy and do the compliance with respect to Maternity Benefit Act. Then there's Labor Welfare Fund, which requires you to maintain and make social security obligations and payments from time to time. So we look at, sample challans to see if the company has been making these payments or not, and if they are in compliance with these laws. Other than that I want to also mention in case of employees chapter is, we also look at the total count of employees and then the appointment letters, so that, if our acquirer is, let's say, acquiring 100% of the shares of the company, then we suggest or we make recommendations to the appointment letters if there are, quite deviated from the best industry practice. That is what we do in case of employees chapter as well. The other section is contracts. In here, in this case, we basically review the contracts entered into by the company. So, and that completely depends on the nature of the business of the company. We intend to look at the material contracts with customers, with vendors, distributors, suppliers, and all the business and commercial contracts. And why this comes into picture is, now let's say I will give you a practical example. Now let's say if there is a share acquisition of a company where we are doing the diligence of company A. Now company A is involved in the business of retail and shopping and basically clothes. Now, the company A with the business in clothes will have different contracts with the fabric suppliers, different contracts with the factory workers, with factories where the fabric is stitched into clothes. Then they will have contracts with transporters where they will, transport the clothes to a warehouse. They will have contract in the warehouse as well. Then they will have contracts with B2B customers, let's say. These are the kind of contracts that we deal with. And basis the business of the company, we need to look at the contract to see, if there's any red flag or if there's any surprises in the contracts that we may want to flag to our acquirer. The next section is on licenses. Now, this is one of the most important chapters from the perspective of legal diligence, and in addition to corporate. Now, licenses are what makes the company, in case of, factories, where company has a factory, not so much in the case of IT or information technology related companies, but in case of factories, where a company has factories, let's say for chemicals, hazardous substances. These are the major form of compliance that we need to look at and that we need to be aware of. Because without the license, if any company is operating without any of the licenses, then it becomes a major issue. And let's say now, I will again give you an example. Let's say there is a company which has a factory of hazardous chemicals, and that company is operating without a factory's license under the Factories Act, which is one of the most primary license which is required to commence or start working under a factory. Now, in this case, while doing a diligence only, we will be able to understand that, the factory's license has not been obtained. So in that case, we will flag it to the acquirer, and the acquirer will then take a decision that, whether we should proceed with the acquisition or proceed with the corporate restructuring or not. And there are a lot of major non-compliances or consequences of not obtaining a factory's license, because the authorities do have the authority to basically shut down the factory. So if the factory of a company is shut down, then the sales will not go up, the distribution will stop. So this is why we need to do a diligence, and this is where the importance of diligence come into picture. Because when we as corporate lawyers ask for the data from the target company, we always ask for all these sections and all those requisitions or clarifications from them, so that we can get the entire data with respect to all these sections. And once they provide the data with respect to all these sections, we review them, and then we flag to our client, who is the acquirer, that, what is the level of compliance in the company. Now, in terms of litigation, we look at all the pending litigations which have been filed by the company or against the company. We tend to understand that what is the status of litigations of in the company, because litigations are a part and parcel of a company, and companies of huge size also will have litigations for sure. But we tend to gauge and understand from the facts of the company, facts of the litigation, that what is the level of success or what is the level of failure of the litigations, so that we know that once we are coming into the shoes of the company, we as an acquirer, if the acquirer, our client, who is coming into the shoes of the company, how much profit or how much loss will they make from the litigations. So let's say if there is a litigation where we understood the facts of the case, and then we made a judgment that this case is winnable. So if we win this case, we will get 50 crores from the other side, because that's the nature of the case, and that's how the judgment are, as per our judgment, this case is winnable and we will be able to make around 50 crores. So automatically, the acquirer's interest in the company or in the target company will increase, because that's how the judgment of corporate restructuring is formed, by way of doing diligence. And that's why diligence is very, very important in case of each and every section that I'm talking about, in order to understand and in order for the acquirer to make a decision to go ahead with the corporate restructuring. Now, lastly, we also talk about the intellectual property rights. We basically look at the copyrights, trademarks, patents, designs filed by the company, or filed, infringement cases in case trademark is owned by the company. We look at the trademark registration. We look at the expiry date. If the trademark registration has been expired, we intend to look at the renewed copy. Then we also look at the compliances required to be done under these IPR laws, if at all the company owns the IP. If there is no IP in the company, then there is no requirement of complying with these laws. So this is how diligence is important in case of, each and every section. And that's why we intend to emphasize on the corporate restructuring when a diligence is done, because it'll help you to understand and find out and dig on red flags or surprises in the company. Now, I will give you another example there, and that's a live example. There is one company which we are doing a diligence on. And in case of that company, we undertake an independent litigation search before the Supreme Court, before the High Court where the registered office is situated. We also undertake an independent litigation search against or filed by the company in case of NCLT and NCLAT. So when we were doing the diligence on a company, we basically did the independent litigation search. And when we were doing the litigation search, we found out that the company has been filed for bankruptcy. So now, if a company has been where a company's office has been basically initiated under the IBC or Insolvency Bankruptcy Code, why would any acquirer want to acquire such a company? Because the financial well-being of the company is not great. The assets of the company may not be worth purchasable. This is why diligence come into picture, and that's why during the process of diligence, we understood that in this case, this was not worth going ahead, and that's why we took a step back, and then the acquirer made a decision not to go ahead with the company. In corporate law, there are immense opportunities. Once law students start understanding the corporate laws which they study in law school, the kinds of subjects that are basically important for corporate law, if they tend to focus on that, there are immense opportunities in the corporate law industry. Unlike litigation, I mean, in litigation, I'm not saying that there are no immense opportunities in litigation, but yes, there are. I mean, these are two separate aspects: one, litigation, and secondly, corporate law. Under corporate law, there are two subsets which are focusing on corporate law. So first is law firms. Law firms, where there are immense opportunities in case of different teams, where we can make a career in corporate law. First is the general corporate team. General corporate team of law firms, what they do is day in and day out, they review the contracts, they review the charter documents, memorandum, articles of association of a company. They look at the secretarial compliances, which also a company secretary does. Then general corporate teams also look at the drafting of the contracts, the negotiation of the contracts. These are the kind of things which general corporate team does. In addition to that, there are also opinions which general corporate teams issue in terms of, let's say, there is an opinion required under the requirements of Companies Act, or if there is any opinion or memorandum required to be issued to a client where they are seeking a legal opinion, that's when general corporate teams come into picture, and that's when their work gets done. Secondly, a subset, or I wouldn't even say subset, but yes, it's basically a bit synonymous, where general corporate team and mergers and acquisitions come into picture, because they're mostly together done. It's not like it's a completely separate team. So general corporate and M&A teams are mostly one and for all. Second, on mergers and acquisitions, what they do is, again, as I said, conduct due diligences on the companies. And due diligence as a fresher at a corporate law level is extremely important, because as a fresher or at the entry level of associates, everyone will expect you to do diligence. And in every law firms, in the first initial 3-4 years, due diligence is what we need to do in order to understand the entire transaction advisory world. Because as entry level lawyers, we always emphasize on the importance of conducting diligence, and that's where corporate lawyers at an entry level come into picture. As and when you keep on growing, you basically come from doing the diligence, summarizing the documents, reviewing the documents, and applying your mind in terms of how the acquisition or how the corporate restructuring will apply in your review. That's what you do in, let's say, 3-4 initial years. Once you keep on growing, other than the diligence, you also start getting involved in the drafting of share purchase agreements or transaction documents. So share purchase agreements or asset transfer agreements or business transfer agreements, these are the kind of transaction documents which come into picture when as step 2 that you need to draft. Because once the diligence is done, once we have our findings ready, that what is the level of compliance in the company, we intend to draft the or asset transfer agreement. So as and when you keep on growing, the drafting then comes on to you. Then once the draft is prepared, it goes to the other side. It goes to the target company side, because they are also wanting to do corporate restructuring, right? So in that case, it goes on to the other side, and then the markup comes in. The markup of share purchase agreement or asset transfer agreement comes in, and then there is negotiation. So in case of negotiation, we tend to involve 7 to 8 years, 8 years PQE lawyer or a partner of a law firm. That's how the transaction grows and closes. So first step is diligence. Second step is SPA or share purchase agreement. Third is negotiation. And fourth is after negotiation, when the share purchase agreement has been finalized, when all the details and the terms of the agreement has been thrashed out and negotiated between both the parties, we close and then we sign the agreement. So once the agreement is signed, on the date of signing or on the date of closing, we the buyer transfer the money to the sellers, and the sellers then transfer the shares to the buyer. That's how the entire storyline of a transaction is coming into picture. And there are a lot of times where transactions just stop at the time of diligence, because at the time of diligence only we kind of figure out that this company is not worth purchasable. So that's why we stop at diligence level also. The third aspect is, in this case, restructuring and insolvency. Now, in this case, the corporate lawyers also play a role, where there is some amount of litigation knowledge also required, because in case of restructuring and insolvency teams, which nowadays law firms have a separate team. Earlier, it used to be that only general corporate teams used to handle the restructuring and insolvency cases. But nowadays, there is a specialized team in every law firm where where lawyers or corporate lawyers look into the restructuring or restructuring cases under the insolvency bankruptcy code. So once the insolvency bankruptcy code has come into the picture, we as corporate lawyers try and understand that what is the level of compliance under the company. Then we look at the cases and represent the clients which are undergoing IBC or insolvency also. Then we also represent cases where we represent the resolution professional under the insolvency bankruptcy code. These are the kind of things which a restructuring and insolvency team does, and these are the kind of things which a corporate lawyer should know if they want to do make a career in restructuring and insolvency. The prerequisite to knowing and being in this industry or sector is knowledge of insolvency and bankruptcy code, because that's the new law and that's the important law where so many companies are undergoing insolvency. When we represent cases or when we represent companies undergoing insolvency, that's when your knowledge of IBC comes into picture. And that's why it should be on your fingertips how IBC rolls out, how the process of IBC works. First, what happens first, then secondly, what happens. These are the sequence of events that a corporate lawyer should know of. Fourth thing is on IT and intellectual property. Now, intellectual property is also a specialized subset of corporate law. Corporate lawyers who want to focus on the intellectual property cases and intellectual property opinions in relation to compliance with intellectual property laws like Trademarks Act, Copyright Act, Designs Act. These are the kind of things that IT and intellectual property team does. And intellectual property team are usually specialized in case of law firms where they intend to handle the IP infringement cases. Then there are also works which are given to IP teams where we are asked to file the patents and help the client in filing patents, help the client in filing copyrights, etc. So these are the kind of things which IT and IP does. Another thing which I want to also point out is competition law, where the competition law is also a subset of corporate law, where under competition law department, you tend to look at the cases which have been going on under the Competition Act. There is a slight bit of touch of litigation as well under the competition teams, because the clients ask you to represent them before the Competition Commission of India. So that's why there is a slight taste of litigation which you also get in addition to issuing opinions under the Competition Act and combination regulations, etc. Now, this is what law firms usually offer. Other than that, there is also a subset of corporate law, which is in-house lawyer. Now, in-house lawyer is basically a lawyer working with a company or an entity or a partnership firm or an LLP, basically a separate corporate body. Now, as in-house lawyer, our role is quite different from what we do in law firms. In law firms, we cater to the clients of different businesses of different size and of different nature. We help them do a transaction. And in case of in-house lawyers, we are the client, because we will be assisting the company in doing the M&A transaction. We will be assisting as in-house lawyers in relation to any and everything, in relation to all the legal things like drafting of contracts for the company, then negotiating with the other side, standardization of the contracts in a company. But we are basically serving as an employee of the company and not catering to different clients. So these are two separate aspects, or these are two separate subsets of corporate law. And broadly, these are the areas where there are opportunities in corporate law. And as an in-house lawyer, we also tend to solve legal queries which they may have as a business team, which business, while making decisions business teams come into picture, and then they tend to ask the legal department that what are the legal risks which we may need to have while doing a certain transaction. So these are the kind of things as in-house lawyer people do. Now, in case of corporate law, to just make a career in corporate law, there are certain prerequisites, I would say, which are required for us to be, be a little more competent in terms of making our mark and focusing on the corporate law world. What people look at and what law firms look at is that you have a basic knowledge of the Companies Act for sure. Companies Act basics are definitely required, and even in interviews, they are definitely required to ascertain that, whether the candidate has basic knowledge of Companies Act or not. The concepts of rights issue, the concept of private placement under section 42, 62, 13, these are the kind of things which a law firm or an in-house lawyer also get asked, that what are these basic prerequisites or requirements under the Companies Act, which a company needs to comply with. Because be it law firm or an in-house lawyer, everyone would need to know. If you are focusing on a career as a corporate lawyer, everyone would want to know the basics of Companies Act. And in case of SEBI regulations, this becomes more important in case of listed companies, because SEBI is the governmental authority regulating the listed companies. Now, SEBI regulations do become important because there are much more additional compliances which are required to be done under SEBI regulations for listed companies, in addition to the Companies Act compliances. So it's so in case of private companies will just need to be compliant with Companies Act. And in case of listed companies whose shares are listed on the stock exchanges, in addition to Companies Act, SEBI regulations will also come into picture, where we will need to do compliance with SEBI laws as well. Like in the case of SEBI LODR, which is SEBI listing and obligation regulations, obligations and disclosure regulations, which basically allow or give you the responsibility to do certain mandatory disclosures to the stock exchanges. So these are the listed company compliances which one needs to be aware of. And this becomes important when in law firms you are catering to a listed company client. And this becomes important in case of an in-house job when you are wanting to apply to a listed company. The third set would be FEMA regulations, and is also one of the complicated laws, I would say, where FEMA regulations come into picture, is when there is a dealing in foreign exchange or dealing in foreign exchange, or issue or transfer of shares from a resident to non-resident, or from non-resident to resident. So these FEMA regulations do come into picture and play a very important role in case of transactions when there are non-resident shareholders involved. So let's say in case of M&A transaction, there are non-resident acquirers, and they want to acquire an Indian company. So in that case, the transaction will be between resident and non-resident. And that's why we need to know these basics of FEMA also. And even at the time of interviews, and even at the time of fresher, placements, some basic knowledge of FEMA regulations is indeed required for them to ascertain that these FEMA laws we are aware of, and we have the basic knowledge of that. Lastly, there are business and commercial laws. Business and commercial laws we basically look at the requirements under the Contract Act, because the Contract Act is applicable to all contracts, and the basics of Contract Act everyone should be aware of, be it in corporate law or in litigation. And then there are certain other laws like IT laws, IT SPDI rules. Then there is Transfer of Property Act. These are the kind of main laws, I would say, which a corporate lawyer should be aware of. And these are the basic knowledge of these laws would make a corporate lawyer go much, much far. Now, in case of law firms, what do law firms look for? Law firms basically look for academic performance. There is extracurricular activities, whether there is a professional course also which is being done, whether they look at the internships that a law student does, and what kind of work which a law student does in the internships. So and research papers, if law students have written research papers, especially in the corporate law sector, then there are articles and blogs which basically show that a law student is doing something in addition to the curriculum. And then there are moot court competitions where there are also moot court competitions specializing in corporate law sector. So this is what law firms usually look for. Having said that, there is no boundary or there is no restriction for any student to apply. Everyone is starting at a new job and everyone is starting at scratch. So it's not like they won't be considered for it, but there is always a preference which is given to law students having a good academic background. Then company secretary courses, because company secretary as a course or any other corporate law course will give you that edge over the other students, where you will have not only the basic knowledge of corporate law or Companies Act, you will also have to deal with live examples or practical challenges which a corporate lawyer faces. So these are the kind of things or things which law firms look for in law students. Any questions? Any questions on diligence, on the career opportunities of corporate law? Anything that you would like me to address?
Thank you, ma'am, for sharing with us the immense amount of knowledge that you hold on this topic. So we would now proceed to the question and answer session. Kindly drop your questions in the chat box. So, ma'am, we have one question from Nishi. What aspect is to be looked into human resources?
All right. So Nishi, in terms of human resources or employees chapter of a due diligence, firstly, while we do a diligence, you must have seen the presentation in terms of what all we look at while doing a diligence. So in terms of human resources or employees chapter, we look at the compliances required to be done under the labor laws, where basically we look at the registrations of the labor laws under the EPF Act, under the Gratuity Act, under the ESI Act. These are the kind of details and registrations that we look for, whether a company is doing a compliance in these laws or not. And then we also look at the challans or contributions which a company needs to make. Now, in case of PF, there is a mandatory requirement that the company makes a specific amount of contribution towards the provident fund. So we look at sample challans to understand that whether the compliance is being done or not under the PF Act. Similarly, in case of ESI Act, that's what we look at, the registrations and the sample contributions to understand the level of compliance in human resources.
Thank you, ma'am. We have another question from Adarsh Gautam. Whether intentional or unintentional, owners, managers, employees, or researchers may influence the results of the legal due diligence investigation. This influence may taint the outcome of the legal due diligence investigation. What is the way ahead in such cases?
Absolutely a delightful question. I would say that in case of diligences, that this usually is not the case, because when the parties of a nature, of a size, of such big companies, if there are such parties, which want to do due diligence and which want to go ahead with the transaction, there would slightly be a lesser possibility of there being a bad faith, or where where employees or managers or owners hinder the process of diligence. But well said and well done. In case, and this may or may not happen, but what corporate lawyers, as corporate lawyers, what we usually carve out is basically that in case of a fraud or in case of unintentional misrepresentation, we usually do not, we go by the word of the target company, and we get the information from the target company, whatever they're giving on the face of it. And that's at least for the scope limitation for corporate lawyers, that is our cover up, that we always rely on the word of the target company. So that's one scope limitation, which in diligence we always say that we are going by whatever they are giving, and we are not in any way responsible if they do any fraud or if they do any misrepresentation, because all of the responses and all of the whatever the responses and representations that they give, that is all written. And if at all there is any fraud, then it is covered in case of share purchase agreement. And where there is a misrepresentation, we will seek damages by the sellers or by the employees.
Thank you, ma'am. Our next question is from Vishnu Sudarshan. What specific basic regulations do we look at to understand FEMA regulations at the ground level?
Yeah. So in case of FEMA regulations, what generally at fresher level or as law students one needs to read is first and foremost the FDI policy. FDI policy, which is the latest FDI policy that we look at to understand that what is the sectors and what are the gaps for each of the sectors in order for us to enter into India, in order for non-residents to enter into India. So FDI policy is one. Second is FEMA NDI rules. Now, FEMA NDI rules for a corporate lawyer is very important. FEMA NDI rules basically mean FEMA non-debt instruments rules, which have come into the picture. So these regulations talk about or provide for transfer or issue of shares to a non-resident, or transfer of shares from a non-resident to resident, or vice versa. So these two aspects are very important to understand FEMA at a ground level.
Thank you, ma'am. We have another question from Sohel. When we are talking about due diligence being done with regards to an acquisition or spin-offs, does a corporate lawyer only look into the legal aspects of the transaction, or will he also have to do due diligence with regard to the project being profitable or its ROI to its shareholders in next few years?
This is a very insightful question again. Now, the role of a corporate lawyer in a legal diligence is only to check the compliance in terms of law or applicable law for the business of the company. What we need to do as corporate lawyers is only the compliance. This is where to check the profitability or ROI or the revenue. This is where financial diligence team comes into picture. So just like how for corporate lawyers or for lawyers, we have legal diligence, for chartered accountants or big four firms, what they do is a financial diligence on the company.
Another question. What sort of due diligence do we have to look into when suggesting a certain structure to a client?
All right, so that depends on the structure again. Now, the structure is usually decided by the client itself. It's not usually decided by the legal counsels, but we also suggest in structuring of the transaction. So while we are doing the structuring, how a corporate restructuring should be done, we tend to look at 3-4 aspects. One is the legal compliance. Second is tax implications, because tax implications are huge when you do a share purchase agreement or when you do a merger. So there are different taxes which are involved. This is where financial advisors advise you in consonance or in togetherness with the legal counsels that how should we structure the transaction. And what sort of due diligence do? We only do legal diligence, at least as corporate lawyers. Financial advisors do financial diligence, and the diligence will not, change in terms of when we are doing different transactions. So even if we're doing a merger or if you're doing a amalgamation, at the end of the day, we will need to do a diligence and look into the affairs of the company. So the diligence will not change, but the structuring will depend on these factors like legal or tax implications, etc.
Yes, ma'am. Thank you so much, ma'am, for sharing with us the immense amount of knowledge that you hold on this topic. And thank you for being so patient and in answering all our questions and clearing our queries.